We'll call to order the recommending committee meeting of October 17th, 2006. May we have our compliance with open meeting? Yes, we are. This meeting has been posted in various locations throughout the city. We'll read the first item. Make sure I have this right. Bill number 2006-57. Amends ordinance number 5834 relating to the annexation of property to correct the legal description contained therein, general location, the southwest corner of Charleston Boulevard and Lindell Road, proposed by Margot Wheeler, Director of Planning and Development.
This was a parcel that you recently annexed, and after the ordinance recorded, it was discovered that even though the map was correct, that they had left out the north 33 feet of an adjacent parcel, which actually had been combined with this lot. So this ordinance goes ahead and adds the additional north 33 feet of the adjacent parcel and completes the annexation. Recommend approval.
Does anybody else wish to be heard on this item? All right, then hearing none, do you have a motion, Councilman?
Councilman, I do. I make a motion to refer to council with a due pass on agenda item 3, bill number 2006-57.
All right. All in favor? Aye. The motion passes. We will now move to the next item. Bill number 2006-58. It updates and strengthens the municipal code provisions so as to better discourage, detect, and punish those who would drive under the influence of alcohol, controlled substances, chemicals, organic solvents, compounds, or any combination of these. Sponsored by Councilman Steve Wolfson. Staff?
Ben Little, the Chief of the Criminal Division in the Las Vegas City Attorney's Office. Councilman Wolfson contacted a group of us in the spring of this last year and discussed his desire to strengthen the DUI and domestic battery laws, do what we could to give our best efforts to discourage those types of offenses. And for those several months we've been working on DUI first, and at his direction to find out different types of proposals and venues for enhancing protection against DUI. I went through the legislative sessions for every state for the past 5 years and kind of pulled out what was being proposed in different state legislatures. So I thought it was a good avenue for looking at the different possibilities for enforcement of DUIs. And initially I had a draft that had everything in there just so that it could be considered by Councilman Wilson. And after culling what was inconsistent with the existing Nevada legislation and what was best left to the state legislature, what was not practical for our venue, we came up with what you have before you, and I'd like to go through the essential changes that it has in the draft we've gotten. First of all, the changes that we have harmonizes our DUI ordinance with the state statute. I don't believe currently in our DUI ordinance there's anything about a per se violation, but one of the things this accomplishes would to be incorporate that per se violation in there. It also defines the phrase actual physical control consistent with the DUI case law, principally the opinion in Rogers versus State at 105 Nevada 230, which I'd offer as an exhibit if I could. So that'll be exhibit 1, I suppose. And Rogers identifies several factors in evaluating whether somebody is in actual physical control of a vehicle for purposes of DUI prosecution. As you see on page 2 of the ordinance, there are 10 factors that are listed. The first 8 would be those accounted for in Rogers. There are 2 others that we see common in discussion and opinions across the country on DUI cases, and that are used commonly by our courts in evaluating whether someone was in actual physical control of a vehicle for purposes of DUI. So we can't necessarily prove that they were driving, but we can prove that they were in a position to drive. The Supreme Court has said that the purpose behind that is to keep people from being in a position so that if they do decide to drive while drunk, that they're not going to. So you punish them for being in a position to drive while drunk, in addition to if they did drive, or in lieu of being able to prove that they did drive. So the Rogers case talks about the first 8. The other 2, whether the person's a registered owner and whether there's any injury to the person which corresponds to the physical evidence within or damage to the vehicle, are in what we experience in court and what has been suggested as factors in different opinions around the country. So if there's a spider crack in front of the driver's position and that person has a head injury, then that would be consistent with that person being the driver. Or if the spider cracks on the passenger side and there's a head injury and the other person doesn't have the head injury, then you would think that second person would be the driver and the first person would be the person who was not in physical control of the vehicle. So it's a factor one way or the other. The next thing we accomplish is to define the phrase under the influence or combined influence for purposes of the ordinance and DUI enforcement. That's consistent with DUI case law, and it's also consistent with footnote 2 in an order that the Supreme Court issued on a Henderson case in 1996. It's City of Henderson versus Reimer, which I will offer as an exhibit, in which the court defines incapable of safely driving in terms of DUI in the manner that we define under the influence here. And so it shows the consistency between what the Nevada Supreme Court would define as under the influence and what we define. It certainly would show that the Supreme Court is inclined to accept our definition as consistent with the state statute. And I'd also proffer to you Supreme Court Rule 123, which points out that this opinion, this order by the Supreme Court, is not legal authority or precedent. It's simply offered to guide you on where we got that language from and the court's inclination to accept it as being in harmony with the state statute. So I'd offer those two. First, the order is number 2, and the Supreme Court rule is number 3. So we've defined actual physical control. We've defined under the influence. It also, this ordinance would allow the court to order DUI offenders to a corners program designed to discourage drivers from drinking and driving. And it would encourage such orders where there's an accident, a blood alcohol content of 0.20 or more, the use of controlled or prohibited substances, inhalants, compounds, or solvents, or the offense is not the offender's first offense, or the offender is under the age of 25. Currently, there's a coroner's program that's designed to deal with youthful offenders who are engaged in risky behavior. What they do is they have 6 scenarios that they go through, life situations where somebody's died. And the participants in the class are shown the pictures of the individual or individuals who died in that event, and the risky behavior is described. Then they're gowned, masked, gloved, and took on a tour of the autopsy room, the back room for the coroner's program. It's been very successful. As you would imagine, the sights and smells in that area are really compelling. I've been to the coroner's office and attended autopsies as a deputy DA. I did it 3 times, once on my own so I could experience, twice so I could go with people who were afraid to go on their own. And that was over 20 years ago, and I still can sense the smell of that back room and know and call back the sights. It's very compelling. And the success rate, and that's been in place for a couple of years now, and that's very successful. I believe it's been a couple of years. It's extremely successful. So what is contemplated by this program to discourage drivers from drinking and driving would be to have something similar with DUI scenarios. Of course, they'd get waivers from family members, which is what they did in the first program. And so they'd give the DUI scenarios to the individuals, the participants in the class, and then they go on their tour of the background. The judges have all been on the tour. They were very impressed by the impact of the program, and so we believe it's a very powerful component to enforcement against DUI offenders. And then lastly, it creates a mandatory minimum sentence for those who would drink while behind the wheel of a vehicle, $300 fine and a mandatory intoxicated driver awareness course. The offense now exists, but there is no mandatory minimum penalty, and it's really there is an out if the judge, the court feels that it's not reasonable to order those mandatory minimums in that specific case. Then upon a finding of reasonable cause, the court can not order the $300 fine and the mandatory intoxicated driver awareness course. So it gives the court discretion not to order the mandatory penalty, but it's basically the rule that they get that at least, unless there's reasonable grounds to believe that that's too harsh under the circumstances of that offender in that case scenario.
Councilwoman, if I may?
Yes.
Can I stop you right there and ask you about that $300 fine? That's kind of whippy, don't you think, considering the offense?
Well, this is a situation where they're not DUI. They have alcohol in their vehicle and they're drinking. They may not have a high BA. And as far as mandatory fines go, it's basically what we've been imposing, along with the intoxicated driver awareness course, which is itself a couple $100. So you're talking about a $500 impact, not just $300, and also time attending the course.
Well, I think I definitely appreciate the councilman's efforts in regards to this ordinance, but I think we need to send a clear message out there that we as a city will not tolerate this kind of behavior, and if we hit people in the pocketbook, they'll start to pay attention. I know we're kind of bound by judges who reduce fines and don't make the financial impact that great. I'm sure folks stand in front of that judge, councilwoman, and say, I can't afford that. I'm on minimum wage or I'm unemployed. The fact remains that there's been a violation, and I think we need to be consistent. And as we move on to these things, because I'm going to talk about something else here in a minute, as we enforce these ordinances, that we send a clear message to this community that we won't tolerate this. We want to make a change. We want people to live. We want our youth to get the idea to do the right thing.
Well, it certainly wouldn't offend me, and I don't know that it would offend Councilman Wilson if the council and the mayor felt that more of a higher fine was more appropriate, and that's probably something that he intended to discuss at the fall meeting too. I would inform you though that there are situations where maybe Metro didn't do a DUI investigation. Maybe the person was arrested for stolen vehicle or some higher crime, so that they just didn't get into a DUI investigation. But there was a container and the person was drinking behind the wheel, and so they booked it on that. So there may be scenarios where the person was actually intoxicated, but they just didn't fully investigate that avenue because they were going on to more serious things. Maybe the person got physical before they had a chance to, or something like that too. So
We could forward it with a recommendation to change that, can't you?
yes, that's an option.
That's what we could do.
And
We have the $1,000 in section 4. We could make it $500.
yeah, $1,000 is the cap for a misdemeanor offense.
Right.
So we could not get any more than $1,000 on a fine.
But
And
I
DUI.
was thinking you could do the 500 on page 4 where you have 300, and it'd be half of the amount on page 6, which is 1,000.
Well, and Councilwoman, if I may ask another question, how do we make these gross misdemeanors?
You'd have to go to the state legislature and have them be gross
The answer I was looking for.
and for the record, the court does waive fines for those people who payment of the fine is a hardship. They first try to make them work it off with community service or a work program, and if they absolutely, the defendant's trying, it's not willful failure to pay the fine, then they will waive the fine. So there is some flexibility there if you do go higher and it's deemed to be too harsh. They'll try to get what they can from them. They'll try to get the work time out of them, and it's the last resort that they do waive it. That's what the Constitution requires. So that's what they do. We have about 5,000 cases of DUI a year. It has not gone up dramatically the last 3 or 4 years. With the population increase, it's surprising to me. It's satisfying to me that it hasn't gone up dramatically. Since for about the past 7 or 8 years, we went from 4,000 a year to 5,000 a year. And I think, as far as the city goes, it's leveled off somewhat, but it's still remarkably high for being limited to the city. I don't know what the county has, but I know that it's at least as much as what we have. So,
Quick question, Councilman, if I may ask him also. That's 5,000 in our city limits.
that's in the city limits, yes.
And because you're here and you're in the criminal division, city attorney's office, and we have city staff here and the councilwoman's here. If we look at the bigger picture in regards to public safety, by doing these type of ordinances, sending a clear message to this community that, again, that the city will not tolerate this kind of behavior. We start hitting people in the pocketbook, and they've got to start going to classes, and they've got to walk through the morgue. I mean, that's going to change things significantly, and I think that 5,000 number, even though our population has grown tremendously, if it stayed steady, that's great. But I'd certainly like to see that decline as we implement these type of ordinances.
Absolutely. And so naturally, I'd recommend do pass with whatever recommended changes you deem fit.
Do we have anybody else in the audience that would like to make a public comment at this time? Or anybody else from staff? No public comment? Then we'll move for your recommendation.
And Councilman, I think the finer details of this ordinance can be discussed at council, and we can bring this up as Councilman Wolfson explains it again to the full council. But I would make a motion to refer this to council with a due pass.
With the due pass, all in favor? Aye. And what we can do is let them know that these were some thoughts we had about raising it.
Absolutely.
Can we?
Yes, Councilman, I just wanted to point out that this will be eligible for adoption tomorrow.
Cool.
So as early as tomorrow, you can make that recommendation. It can be adopted tomorrow, or if there's a desire to hold it, it could be adopted November 1st.
Let's rock and roll. Let's get it on.
Yes. You could talk with Councilman Wolfson, who developed this, and let him know our thoughts, and perhaps move from there as he explains.
Is that the only change that you're contemplating? Because I can do a First Amendment. I can type up a First Amendment for tomorrow.
If I may, Councilman, I would
But I don't know what number you're going to
recommend you
end up
confer
on.
with Councilman.
Okay.
I'm not sure we're going to have an opportunity to prior
Okay.
to this coming up. I don't want to hold it. I mean,
Or we could have it ready, couldn't we, and then let Mr. Councilman Wolfson know, and you could then try and contact Councilman Wolfson?
Yes.
Or did you want us to?
I'll contact
If you
council.
can, that would be good, because we get busy on Tuesdays.
Sure.
If you could do that and let him know that this was our suggestion, but we didn't, we feel it should go through him because he's the one who set up this,
Okay.
and then you could
So change that 3
let
to
him
500.
know, but you could have it written up and have it ready to go,
Absolutely.
because as you said, it's only a day.
and Councilman, if I may, I want to express my appreciation to your efforts in your office, pulling those laws from the other, and legislation from other states, I'm sure was not an easy task to do. You mentioned earlier, as you started your presentation, about domestic violence, and I'm sure that we will soon see a domestic violence ordinance very similar.
I'm not sure how soon, but he wanted us to get to
I'm
that
sure.
right after this.
I've spoken to
project
him,
was done.
and again, it's in the great efforts of this city to send a clear message to this community that we care about our citizens. So
Thank you.
Thank you.
All right, now, is there anybody who wishes to participate in the citizens part of this meeting? Any citizen participation comments?
My name is Ted Russell, R-U-S-S-E-L-L. I'm sorry.
You get to sing.
You get to have your own mic.
My name is Ted Russell, Russell, a resident of Las Vegas. I just want to say that I concur absolutely and exactly with everything Councilman Ross has said, that we do care about our citizens, we care about life, we care about our youth, we care about a community that is successful, and that's always the advantage of life. And I'm very heartened that we will be dealing with the issue of domestic violence and be sending a clear signal of zero tolerance. I can't thank you enough, all of you, and have a great day.
Anybody else wish to speak?